Good morning, everyone, and welcome to today's webinar on the implications of consumer protection regulations for estate agents. Joining us today to give the webinar is David Beaumont of Compliance Matters. David has spent many years in the industry, formerly as a trading standards officer, providing support and training for estate agents on the implications of all kinds of compliance. And we're delighted to have David here today. The webinar will only be a short one. It's to give you the main things to focus on within consumer protection regulations, and we will be offering the opportunity to submit questions during it, but to keep it short rather than to respond during or after the webinar, what we'll do is we'll collate those questions and we will put together an FAQ and send that out to all of today's attendees. So without holding you further, here is David. Thank you.
Thanks, Ben, and welcome to my Consumer Protection from Unfair Trading Regulations presentation, where I'm hopefully going to give you an insight into these new approach regulations that now apply and that took over from the Property Misdescriptions Act. I used to love the Property Misdescriptions Act. It was a great piece of legislation. Basically, if you made a description, you had to make sure it was right. And if you got it wrong, then you potentially had a problem under the regulations. But there was nothing in those regulations that forced you to make any descriptions about any aspect of a property. You could decide. And there was an old expression I used many times, which was, if in doubt, leave it out. Unfortunately, consumer protection regulations changed all that. And now we have to look to a different route for compliance. As I've said, these are new approach regulations and they apply to estate agency and letting agency. The regulations ban 31 specific practices, which we don't really need to worry about because most of them don't impact on estate agency practices. Unfair commercial practices are banned, aggressive practices are banned, and misleading actions and omissions are banned. The thing that really affects estate agents and letting agents is the last one, which is misleading actions and omissions. Misleading actions, fairly straightforward. It's the old Property Misdescriptions Act. If you make a description, make sure it's accurate. If it's false or it's misleading, then you potentially breach the regulations. So that stays the same. Nothing changes as far as that's concerned. The problem arises with the next word, which is omissions, misleading omissions. And later in this short presentation, I'll be talking to you in some detail about what that potentially can mean. So, just to point out that these offences are strict liability offences, and as such, it doesn't matter why you committed the offence. If you get it wrong, it's an offence. Trading standards officers only need to show or prove that you breached the regulations, that there was a misleading description or there was a misleading omission, and then there is an offence. It then revolves around due diligence and whether you had any due diligence that you could argue. Due diligence becomes very important under these regulations. So, if you breach the regulations, what are the consequences? Well, unlimited fines, 2 years imprisonment, prosecution and defence costs. They can be the most damaging of the lot, because prosecution, their costs can be £10,000 without a problem. If you're defending a case, then the costs can be double that, really, without a problem. The court can award compensation to any consumer that's suffered a loss as a result of your misleading omission or misleading description. The National Trading Standards Estate Agency team can issue banning orders, which can then prevent you from acting as an estate agent, and that can be done if you breach these regulations. The CMA can can acquire assurances from you under the Enterprise Act, which means that you have to sign to say that you will not breach those regulations in the future. And if you do, then High Court action for contempt of court can follow. And the final thing is, Ombudsman can make an award. Quite often people want to go to the Ombudsman to make the complaints, because the Ombudsman will get them some form of compensation, where running it through trading standards and a prosecution won't necessarily get them anything. So therefore, Ombudsman awards can be anything up to £25,000. Let's have a look at some basic offences, which you probably all be aware of from the PMA days, but if you make false or misleading descriptions about a property, that will be an offence. If you don't remove sold properties from websites and portals after a reasonable time, then that will be an offence. Guidance that's been issued by the National Trading Standards Estate Agency team says it should be a reasonable period, but they don't stipulate what that reasonable period is. I think it's probably reasonable to leave them on there for a short space of time, maybe 3 months at the most. After that time, then you're potentially going to have a problem if somebody makes a complaint. If you're making new on the market claims or new instruction claims, then do it only for reasonable periods, not unreasonable. Again, 2 weeks, 4 weeks is probably the maximum for making those sorts of claims. Make sure you're including VAT in your quoted fees, because again, these regulations can be breached if you're not open and transparent about your fees to consumers. Flyboarding. Some of you will know what flyboarding is. Basically putting boards up on premises that you've not been instructed to sell. Trading standards take probably 2 or 3 prosecutions a year against agents who decide that they're going to flyboard. If you want to exaggerate your sales record or your position in the market, then again, potentially you're committing an offence. So if you want to make claims about how good you are, how many properties you sell, that you sell more properties than any other agent in the area, make sure you can prove those claims, because if you can't, you will potentially breach the regulations. Let's have a look at this misleading omission. The offence actually says a misleading omission, commercial practice is a misleading omission if it omits material information and as a result it causes or is likely to cause the average consumer to take a transactional decision he wouldn't have otherwise taken. Now that's completely different than the old PMA days of don't give a false or misleading description. So for example, we're talking about material information. We need to work out what material information is. We need to find out who the average consumer is. We need to know what a transactional decision is. There are all sorts of elements to this that didn't exist previously in the Property Misdescriptions Act. So, let's quickly talk about transactional decision. A transactional decision is anything. If a consumer does anything, if they walk into your office, if they pick the phone up to give you a call to say, hey, I'm interested in a property, those are both transactional decisions, and as such, if you don't give consumers the right information at the right time, then you can commit an offence. Now, let's look at what a misleading omission might be. I'm going to illustrate this in a simple and very straightforward manner. Here's a property. It's taken from an estate agent's details, from the brochure, and it's down in Kent, a place called Dungeness. And the agent took a photograph looking out across the shingle banks at Dungeness, very picturesque, and I think you'll agree, looks like a lovely little property. However, if you look at the property from the other direction, there is Dungeness Nuclear Power Station, and it's very close to Dungeness Nuclear Power Station. Therefore, is that a misleading omission to show the photograph, the initial photograph that I've just shown you? Well, the simple answer is probably yes, isn't it? Because it's material information that the property is situated very close to Dungeness Nuclear Power Station, and we omitted it by only showing you the first picture, so therefore that's a breach of the regulations. Now that might be a very, very clear breach, and more often than not you don't have very, very clear breaches like that. There's not many nuclear power stations around in the UK, but it illustrates the point hopefully. Now, what this is not saying is that you should show photographs like this one in your details. You can show the initial photograph of the property from its best angle absolutely without a problem, because you then have to deal with the potential for an omission. So how do you deal with that? Well, it's straightforward. You simply explain that the property is situated close to Dungeness Nuclear Power Station. You could do that in the directions to the property. You could do it as an agent's note on the details. You could do it in any way you like, providing you give that information. So no consumer could ever say that they weren't given the information. So, just to clarify, it doesn't mean to say that the photograph you're showing must show any detrimental information. It just means that you have an obligation to tell people what that detrimental information might be. So, is there anything in the vicinity of the property that will impact on the owner's enjoyment of it? Yes. Then you should give some indication of what that problem might be. So, let's have a look at some other issues that have arisen. The National Trading Standards Estate Agency team say that potential buyers need to know whether there's anything close by that would impact badly on the occupier. We've just talked about that. Are there any rights of way affecting the property? Buyers need to know about that. Full details of any parking facilities should be provided. Are there any missing main services? Are there any areas of shared ownership? Are there any sitting tenants? Is the roof space leased to a solar panel provider? Does the property have Japanese knotweed? These are all issues that would be seen as misleading omissions if you didn't explain them or outline them or tell potential buyers about them. Furthermore, the National Trading Standards Estate Agency say any significant non-standard features about the property should be disclosed, substantial limitations on the use of the property should be disclosed, any issues with title to the property, and any major structural defects. Now, you're not a surveyor, you're not a lawyer, so therefore you wouldn't know the answers to these questions. However, you will know the answers to these questions once something goes wrong. So a sale falls through because of a structural defect that was highlighted in a survey. There was an issue with the title to the property because the initial buyer withdrew because of that problem. Now you have that information, you have to pass that on to your potential purchasers, otherwise you will be misleading them by not giving them all the material information that they require. Let's have a quick look at practical due diligence. You need to ensure that you take some practical steps for compliance, and so what can you do? Well, you've got to have simple procedures and instructions for your staff to know what's expected of them. You should be training your staff to follow those instructions. You should be giving them training, whether that's in-house training, whether that's online training, whether it's face-to-face training. It doesn't really make any difference providing you're giving them training so that they understand what their obligations are. Make sure that you've got a check sheet on the property file. Make sure that certain steps take place so that nothing gets missed. Make sure you get approval from your client of the details. Any brochures you produce, your client should be approving the details. Make sure you have a process for dealing with property issues, so you need a property questionnaire. ETSOS have a property questionnaire that you can download from their website, so why not use it? It will save you some problems, and it will give you that due diligence, practical due diligence. Once you've got some potential material information, then you have to have a process for dealing with it. So therefore, there is a route you can take to either disclose it, or you can decide not to disclose it. Whichever you decide, you have to have something in writing that will give you that due diligence defence should anybody question the steps that you're taking. I have a compliance disclosure flowchart, which if any agent is interested in getting a copy of it, then all they need to do is send me an email to david@compliance-matters.co.uk, and I'll send you a copy of the flowchart which will show you how to deal with compliance to these regulations. It's not very complicated, it's very straightforward, but if anybody would like a copy, then please feel free to email me. I've given you a bit of background into legislation and a bit of practical advice. Hopefully you found it useful, and if you need anything else, again, you can contact me on the same email address that I've just given you. Thank you very much.
Thank you very much, David. That's a superb insight into the main elements of consumer protection regulations. If anybody needs further information or would like further training on consumer protection for either themselves or the staff, please do get in touch with ourselves or David, as he can certainly provide that support for you. In terms of implementing a system, making sure you're collecting the information, make sure you're providing it at the earliest possible opportunity consistently across the business, and having an audit trail of all of that. Our system does that for you, can take away the headache and let you get back to the revenue generating activities, compliance in a box. We do offer a free trial on that, and if anyone's interested, please do get in touch and we can provide a demonstration either in person or over the phone. We will be running a series of these seminars over the next couple of months on different subjects, so please do look out for them. Also, any feedback is much appreciated, and like I mentioned at the start, we'll be putting together the questions that have come up from yourselves today into an FAQ, which we'll send out within the next week or so. Thank you very much for your time, everyone, and look forward to hopefully having you on board at another seminar in the near future.